Great. Well, first of all, thank you, Ann Applebaum and President Tony Boyer. I think it's amazing to be here today with all of you. I've been at IFES for a very long time, and it's remarkable to see all of you here. We really thank you. I think as was just described earlier, this really is a celebration of election administration in a strange way, and it doesn't happen very often. The work that you all do is not something that's recognized very often, but it ought to be. And I think the discussion about this being central to the defense of democracy is so important. I think this exchange over the next 3 days will really highlight the differences of our democracies, but also what we have in common. Tomorrow, I think, is going to be a historic day, however it comes out. So you're all here to be part of history. I have a colleague of mine who has said that to me in the past, that we have the good fortune to be part of history in these elections that we work on. And so I think tomorrow will be clearly that type of day. Today, we really will be talking about the US electoral system that is very unique and it's very old. And then we will have some questions. Unfortunately, one of our panelists who was supposed to be here this morning, his flight was delayed last night. So he is not here to join us right now. He may come in during the panel, and so we will turn to him. His name is Joshua Douglas. He's a professor and associate dean for faculty research at the University of Kentucky Rosenberg College of Law. And I'm very, very lucky to be joined by Rebecca Green, Professor Rebecca Green. She's the co-director of the election law program at William & Mary Law School. She and I have been colleagues for a very, very long time. She sends IFES a lot of great fellows and interns that have worked with us over the years. Joshua is going to talk about the Electoral College, so I'm going to jump into that a little bit, and then Rebecca and I will discuss it some. As Anne was indicating, it's the original system, the Electoral College, that we have adopted and not really changed. As you know, it was originally designed to be a balance between large and small states, for there to be an agreement on an electoral system that all of the states could agree upon. That, over time, has proven to be difficult. As you know, when we have the winner of the popular vote not win the election. Oh, look, we have...
That's so great.
Great, thank you for joining us. A heroic effort to get here, I promise. So great. Joshua, thank you for joining me. I was trying to talk about the Electoral College before you joined us, so...
Well, I'm happy to do so.
Exactly.
Good to be here. Good morning.
Good morning, yes, great. I was talking about how the Electoral College was originally adopted and why. And so a question that I have for you, now that you've joined us, why was the Electoral College chosen, and what are its basic components?
Yeah, so a lot of people think that the Electoral College was this grand idea that the framers of the Constitution came up with as an effort to perhaps protect small states or take the people away from a direct election, but it was actually a compromise position that sort of no one at the Constitutional Convention really liked, but it was the next best solution that they all came up with. So the proposals as the convention went along were, one, to have a direct election of the president by the people, but a lot of the framers were not excited about that idea for a variety of reasons. The other was to have Congress just choose the president. But again, people thought that perhaps gave too much control to the federal government. And with only a couple weeks left at the Constitutional Convention, they actually sent it to a committee and said, basically, you deal with it, with long, hot summer days in Philadelphia. And the committee came back with this idea for the Electoral College. And I think the basic reason was it seemed like the next best of both not giving a direct election of the president, but also not giving it to Congress itself, but instead creating this other body. Now, there were certainly some of the framers who thought, let's protect the southern states and the smaller states, the southern states in particular given slavery, and the issue of slavery and the idea that the southern states wanted essentially outsized power to have an influence on who became the president, as well as this concern about not sure that they wanted to trust the people, and so they thought they could essentially create an independent body that would get to do this election.
Great, thank you. And there's of everyone in the audience, if you don't know, most people already know this. It is the number of electors is 435 based on the number of people in the House of Representatives, 100 senators, and then 3 electoral votes from the District of Columbia. Josh, how has that manifested itself over the years that we've capped the number of seats in the House at 435, and how has that manifested itself in the apportionment of votes and the electors?
Yeah, because the House of Representatives is capped at 435 under federal law, that means that the number of electors has stayed the same, but population distribution has, I think, skewed in many ways, and so you have the largest states like California and Texas have a smaller role to play in determining the outcome of the Electoral College as compared to the smaller states like Wyoming or North Dakota. Those states have 3 Electoral College votes because every state gets 2 for your U.S. senators, and the smallest states have 1 member of the House. And so you have states that have just 3 compared to California's population, which is many more times the size of Wyoming, and yet it only has, I think it's 55 this year. I can't remember exactly. I think that's right. Electoral College votes. So, almost 15 times the number, but the population is probably 60, 70 times the population of Wyoming. And so what you do get in today's environment is that the smaller and the more rural states have a much more outsized role in helping candidates get that Electoral College majority. And then I'm sure we're going to talk about the so-called swing states and why really the election will come down to 7 states this year, as it's kind of done in many past years.
Right. And that seems to change depending on demographics and whatnot.
A little
those
bit,
swing
but
states, but they've stayed relatively similar.
Yeah.
What are some of the, I know that many people think, okay, we need to change the Electoral College. And most people think it would take an amendment to the Constitution, but are there other types of ways that people are trying to change the Electoral College?
So there's one idea that's gained a lot of traction called the National Popular Vote Interstate Compact. So the U.S. Constitution says that each state gets to determine how to appoint its electors to the Electoral College. And at the founding, many of the states simply had their legislature, their state legislature, decide who won the Electoral College votes from that state. These days, every state has the people do it. 48 states, it's the winner of the statewide vote gets that state's Electoral College votes. In 2 states, Maine and Nebraska, you get 2 for the statewide winner, and then they split it up by district. A lot of people are talking about the Omaha district in Nebraska as because that Nebraska has typically gone Republican, but the Omaha district is typically blue, is Democratic. And this is a little different from the question. I'll get to your question in just a second, but people have been asking me what the nightmare scenario is for the presidential election, and to me, as an election law professor, there's really 2. And one involves a 269-269 tie in the Electoral College. And it's almost definitely not going to happen. But the way it would is if Pennsylvania, Michigan, and Wisconsin all go to Harris, the other swing states go to Trump, but the Omaha district goes to Trump. And if that happened, you'd get a 269-269 tie. And it's a nightmare scenario because I'm not sure the American public would accept the next set of process, which is it would go to the House of Representatives voting by state delegation. So there'd be 50 votes. Each group of members of Congress from the state would collectively decide their one vote for how to decide the presidency. But in terms of the National Popular Vote Interstate Compact, so I wound up with that because so each state gets to decide how they want to appoint their electors. And so what this idea is that states will say, instead of giving our electoral college votes to the statewide winner, we're going to give it to whoever wins the national popular vote. So I live in Kentucky. We have 8 electors. And if Kentucky were to enter into this compact, it would say, instead of giving our electoral college votes to who wins Kentucky, we're going to give our votes to the national popular vote winner. Now, the compact doesn't take effect. That is, the states have all said that have passed this, and there's about a dozen or so states that have passed it already, equaling about 200 electoral college votes. Actually, I think it's more like 15 states that have passed it, equaling about 200 electoral college votes. But they've all said that we're not going to pass it, we're not going to implement it and start to use this idea until enough states have passed it to equal 270 electoral college votes, which is the number you need to win. Now, not surprisingly, the states that have passed this are the Democratic-leaning ones, because Democrats have been on the so-called wrong side of the Electoral College when they've won the most votes nationwide, but not the Electoral College twice in the past 5 election cycles. So it hasn't gotten enough states and enough red states to pass to equal that 270 where it would go into effect. If it ever did, I think there would be pretty strong constitutional challenges to it at the U.S. Supreme Court. The one I think is maybe the most amusing is that the Constitution says that states can't enter into compacts with each other without congressional approval. And they literally called this a compact. They called it the National Popular Vote Interstate Compact. Now, proponents argue that it's not like a compact and that it's not like a trade agreement between states, which is what that clause is supposed to mean. But I think it would face some significant challenges at the Supreme Court. But that's the basic idea and the idea that's gained the most prominence.
Great. Yeah. I think that the issue of if it is tied and it goes to the House, I think we can't stress enough that it's not a majority vote in the House. Each state gets one vote.
Yeah.
So there would be a majority of states that are Republicans, therefore they could vote, and it would still, the popular vote would not be reflected, correct?
Probably, yeah. Well, and so it's the Congress that takes office on January 3rd.
The new Congress.
The new Congress that takes office January 3rd that would do it on January 6th. So right now, Republicans control most state delegations. That's probably still will be the case, but we don't know.
Yeah.
And so, yeah, I don't think the country is ready for that kind of
Right.
chaos. And meanwhile, the Senate would choose the vice president. So you could even be in a situation where the Republican wins the presidency and Tim Walz, the Democrat, wins the vice presidency based on the Senate voting for vice president. So it would really be a nightmare scenario for explaining to the public and the public having accepting that process. Although it is what's in the Constitution.
And us election lawyers, sorry, we think about the worst case scenario, I think, sometimes, and think about what will happen. I highly doubt any of this will take place.
Yeah, I don't think it will either.
Yeah, exactly. Rebecca, what is, there's this Electoral Vote Count Reform Act that happened after the 2020 election. How does that play into all of this, and what are some of the changes that were made?
Yeah, so I don't think I have to tell this audience that we had a little trouble the last time around on January 6th, 2021. And members of Congress, in a bipartisan way, passed the Electoral Count Reform Act in 2022 to address some of the issues that arose on January 6th. And they made some really important changes to the process that are running for the first time in this election. So there are a number of them. I'll just describe a few of them that I think are key. The first is that the Electoral Count Reform Act, known as the ECRA, requires that the election happen on a date certain and that the legislature not be able to sort of change the rules after the election, i.e. after tomorrow. So the rules that are in place can't be changed, by which I mean a state legislature can't decide to appoint electors, for example, after tomorrow. If it doesn't like what happens tomorrow. So that's sort of a first very happy reform because it was a little less clear because there was some language in the very old law that governed this process that arguably gave state legislatures a little bit of wiggle room. Another thing that the Electoral Count Reform Act does is it requires that only a certain person within a state has the power to certify electoral counts in their state. And that is the chief executive, which is the governor usually, although a state can choose a different person, but they have to have one person in charge of establishing who gets the state's electoral college votes. And that, again, is a little bit of a different system in the sense that it was vague prior to this ECRA passage. And so now you have a situation where hopefully the risk of having multiple slates coming out of a single state is now addressed because only one person can certify the actual count. So that's hopefully going to be helpful. There are a few other things that the Electoral Count Reform Act did that I think are important. Two of them address what's going on in Congress on January 6th. And so the first thing is that it makes very clear that the vice president, who this time will be Kamala Harris, has only a ministerial role. That is to say, the vice president who sort of accepts the electoral count, the electoral college votes on January 6th, will not have any decision to make about which electoral college votes to count. In other words, she will just accept those votes and sort of hand them over to the counting process, which of course was an issue with Mike Pence in 2021. And then finally, the different thing that will happen this time is that in 2020 and previously, it only took one person from each chamber of Congress to object to a state's electoral count. And so this time, that objection threshold has been raised to 1/5 of the members of each chamber, which I think is a significant improvement over the last model, in the sense that it takes a consensus of quite a few more people before an objection will move forward. So that is very helpful. So I think I've gone through the sort of the major features of that act, except one I guess I'll mention also. So the other, I think, important reform in the ECRA is that there is now a 3-judge court that can be assembled, a federal court, that candidates can bring concerns to, and it's a sort of an expedited review process. So I think that kind of dispute resolution piece could play a big role in resolving problems that may arise in the next weeks and months. So I think I'll start. Yeah,
those are the major ones, and you've both worked in this field for a very long time. Federal election reform, how rare is it that this has happened?
Yeah, I think it can't be stressed enough how important it was that a bipartisan group of Republicans and Democrats in Congress came together to pass these reforms. You may or may not know that the U.S. Congress is very hard to achieve consensus, and so I think there was a lot of fear that partisan infighting would prevent these very necessary reforms. But I think this is an example of election legislation passed in the correct way, that is to say, in a bipartisan way, behind the veil of ignorance, before anyone knew how any particular reform would affect any election. And so I think it was a shining example of how election reform should happen.
Great, thanks. One last thing about what we're going to see over the next few days is just the timeline. I don't know if people. So I'm forgetting what day. It's not December 11th. I think it's earlier that each state has to certify.
December 11th.
It is December 11th.
December 11th. Yes.
So each state has to certify, and then on the 17th, each state's electors will vote. And then it's counted on the 6th of January.
And that's a change. We used to have something called the safe harbor deadline, which was a date by which states could submit or certify their electoral college voters, but and if they did so by that date, Congress was obligated to accept those counts. But now, this year, for the first time, we'll have a hard deadline, which is to say that states have to, any kind of post-election conflicts, like recounts or contests, must be complete by this date certain. So it's no longer kind of a do it if you can by this date. It's an actual sort of strict deadline by which states have to certify their results. So that's a big change this year.
Yeah, I think that timeline, few know that tomorrow is really just the beginning of the process, really. I'll turn past the Electoral College, and Josh, why don't you, most of the places in which we work, there's one election management body that oversees the entire electoral process. There's one set of rules. It's administered throughout the country. Each polling center should be set up the same, have the same ballot, everything else. Could you describe a little bit about, as people go to Maryland, Virginia, and DC tomorrow, what they're going to see?
Yeah, and this is something that when I have had the fortune of going to other countries to do some research on election law, people are really surprised at how decentralized our system is, as well as how partisan our system is in terms of the election administration itself. I mean, I think we're the only modern democracy that elects our election officials in partisan races in many places, and states elect their chief election officers, typically the Secretary of State, wearing a party label. And then even at the local level, the county clerks in most places are the ones that administer the local elections. And they also, in many places, wear partisan hats. Now, I think that virtually I'd say that most election officials, if not all, are really heroes of democracy for taking off their partisan hat when they're working their jobs. But I do think it leads to this question of legitimacy that sometimes comes up, and of confidence that people have. Are they being partisan? You do hear some different examples of that. But what you're going to see when you head to Maryland, DC, and Virginia are different rules about the way elections are run. Even things like polling hours and the different polling hours when the polls open and close. Different voting machines. Now, most of the country has moved to a paper ballot system with a machine count. So the voter fills out their ballot in paper, and then it gets counted through a machine. There are some places where you have the voters vote on an electronic machine that then prints out the ballot for them to verify. So there are different mechanisms for the voting machines. You'll see some places with respect to the poll workers where some states have laws that say you have to have an equal number of Democratic poll workers and Republican poll workers working the polls. States have different rules on how far away people can campaign, what we've sometimes referred to as the campaign-free bubble or campaign-free zone, how close you can be with respect to having those outside the polls advocating and electioneering. States differ on whether you're allowed to wear political paraphernalia to the polls. Can you wear a MAGA hat in favor of Trump or a Harris Walls shirt when you're waiting in line to go vote? And so states have differing rules on that. So it's a very decentralized system, and even within states, they might have different rules with respect to the machines that are used, the number of polling places, whether voters have to go to a polling place tied to their home address, a precinct, or whether they can go to a vote center in the anywhere, any vote center in the county and cast a ballot. At the vote center, they're all the poll books are electronically linked in that system, so that if you check in one place, you can't go to another. So, without getting into specifics of what the DC, Maryland, and Virginia rules are, and of course the process would look different in the DC metro area in Virginia versus what it might look like in an hour or two away, just because the local authorities have so much control over how they set up their polling places and what the election system looks like, with of course some baseline rules from the state in terms of the voting hours and that sort of thing, but a lot of variation in how voters get to interact with the system.
Right. Yeah, it's remarkable that I'm from Washington State, and so everybody votes by mail there.
Yeah.
Where you can go to other places where you have to vote on election day, basically, and it's mostly a paper ballot now. I think there's one state, is it Louisiana or Mississippi? There's one that still uses direct reportable electronic machines, one state.
Yeah. And then, there's 3 states that don't allow any early voting. So the the places you'll visit have all been voting already, and any voter can decide to, without an excuse, vote early. But there are 3 states that don't have any early voting allowed without an excuse, and so voters will have to show up to vote on election day, and that's New Hampshire, Mississippi, and a third, I forget the
But they can vote by mail if there's early absentee voting.
Not excuse-based, though, in those places, So, every state has excuse-based absentee, but in those states, it doesn't include no excuse absentee either.
And Rebecca, what do you think? I remember, and I think it was in 2008, and I was going to a polling center with the election commissioner from Pakistan, and he was watching the system. And he said, I cannot believe how much trust is in the system, the way that Americans were viewing the process. In your experience working on this issue, where do you think, I know the Pew Center has shown trust. Well, there'll be a whole panel about trust later, so I won't go into that too much. But how much do you think trust plays in this system that is so diversified?
Yeah, a lot is the short answer. But I think that often we describe partisan election administration in the United States as a bug of our system. In other words, a problem because we have partisans involved at every level of our election system. But I've written recently arguing that it's actually a feature of our system in the sense that we rely on the adversarial system in our elections to put partisans from both parties, both major parties, at every level of our election process as a means of securing trust. That is to say, as a means of helping ensure that the process is transparent and accountable by putting adverse partisans in the room. It, of course, isn't a perfect system, but I think that is a real feature of our system that it sort of consciously imposes by partisan actors acting impartially, as Josh suggested, but by name, sort of labeling partisan actors within the system to try and serve as a check and to produce reliable elections. So you can see it, for example, Josh was mentioning that some places require poll workers to be from different political parties, or you may have observers who are appointed from different political parties or candidates. But the idea is let's get everybody in the room and put all eyes on the process as a means of securing accountability and trust.
Yeah.
And I think that really works in places where the requirement is that there's an equal number of the partisans on both sides.
Yeah.
The problem is where you get to some states that
Proportion of the
you have more Republicans than Democrats or more Democrats than Republicans, because sometimes then you see these party line votes on election administration. So we're seeing that in Georgia right now, right, where the Georgia Election Board has voted on various rules on a party line basis, and it took litigation to strike down some of those rules. Whereas other states do it where it is an equal number. They have to work together or nothing will get done.
Yeah.
And so I think, I don't know, I wonder if your research has found that the trust is higher in the states with the equal number versus the skewed number.
I think it's definitely an imperfect process, and there are many states, for example, that have a more partisan skew where one party has much more control. There's also all kinds of trouble with states where it's very hard to recruit members of the opposing party to work in elections just because of the political complexion is very sort of one party or the other. So it's not a perfect system, but I just think it's important to understand that the design is trying to inject partisanship in a conscious way to improve accountability and trust.
I also think in many countries we try to legislate or have the rules be so specific that there can be no, the trust is coming out of the law, but I do think in the end of the day, individuals have to make decisions. And so it's good to try to figure out these ways to deal with trust. One thing, Rebecca, that I wanted to talk to you about was, the United States clearly, when we were founded, did not have equal participation of people working in the elections, and there has been legislation and acts and things that have moved us to allow for more involvement in the elections. Could you talk about some of the major turning points maybe about where the United States has become a more perfect union, where we've become more inclusive?
Yeah, so when this country was founded, of course, you had to be a propertied white male landowner to, even access the franchise. And of course, that has been expanding gradually. I should say expanding and contracting, unfortunately, over the course of this country's history. But the kind of progress of history has been to expand and protect voting rights for minority populations and women. So I don't know how much time we have to really talk about this, but there have been several instances, both by amendment of our Constitution, in the example of women's voting rights in the early 20th century, and then through the civil rights struggles during the 1960s, where important legislation was passed at the federal level, namely the Voting Rights Act, which was attempting to very directly address continuing discrimination against minority voters here in the United States at the federal level. And then really the Constitution itself, the Equal Protection Clause in particular, and even the 15th Amendment, have been regularly used in court to address voting rights issues. There's a constant battle that's being waged that we're seeing in the current Supreme Court between this idea of running a colorblind election, that is to say, assuming that race shouldn't matter at all in elections, versus sort of the opposing view that we very much need to still think about race as we administer our elections and ensure that they're fair and equally open. So I think I'm being purposely vague.
Yes.
I don't know. I teach a class on this, and it takes a whole semester. So I don't know, Josh. I don't know if you want to kind of. Josh has written a lot about this recently, and maybe you want to add. I don't know.
Well, so one thing I'll add, just because I don't know if any of the polling places that the group will be visiting tomorrow include in Tacoma Park, Maryland, which is just over the border. But it's another example of the variation that you'll see. In Virginia and DC, the voting age for all elections is 18. But in Tacoma Park, Maryland, 16 and 17-year-olds can vote in local and school board elections, right? Because we don't just have the presidential election on the ballot. There's many different things being voted on. I actually don't know if Tacoma Park has any city council or school board races on the ballot tomorrow. But if they do, a 16-year-old could go and check in, and they would get the ballot that only shows school board elections or local elections. Whereas if an 18-year-old goes, they'd get a ballot that shows that plus all of the other elections on the ballot. The same goes for non-citizens. There's been all this frenzy, and you may have heard about this narrative about non-citizens voting. There's been a lot of litigation in trying to make sure non-citizens are not on the voter rolls. But actually, there are some places in the U.S. where non-citizens are legally allowed to vote in school board elections or local elections. And Tacoma Park, Maryland is one of those as well. And so the election administration part does get a little more complicated for some of these places that have to make sure that individuals are getting only the ballots that they're, only the local specific ballots if they're non-citizens. Now, the other thing just about that issue is that non-citizens are not voting in any measurable degree illegally. I wrote a column last week for a publication, The Washington Monthly, that goes through some of these details if people are interested. But in terms of the local variation and the eligibility, I know some people here are from countries where 16-year-olds are allowed to vote in all elections, but the U.S. is actually debating that issue, at least in some communities at the local level.
Yeah, we've done some research on that too. Of voting early usually will vote more often and be more engaged. I went to vote at an early voting center in Maryland, and they asked if we were from Tacoma Park because my 16-year-old was with me. Oh, yeah. So now I know why. I didn't know that.
Yeah, so there's Tacoma Park, Hyattsville. There's a few other places in Maryland that have done it.
I think, so just everybody in the audience knows, there are also very clearly major issues in regards to boundary delimitation, money in politics, and mail-in and out-of-country voting. These are huge issues we're not discussing today because there will be panels dedicated to those issues going forward, so we're not overlooking them. We just wanted to mention that those will be discussed. But for you guys in this last bit, I know we're also going to have, on Wednesday, there will be a discussion about likely litigation that's going to happen. What do you guys see in regards to litigation that has been happening that maybe have changed things, and or what you see could be real litigation that happens after the election? Rebecca, I'll go with you first.
Sure. Well, maybe I'll talk about the pre-election litigation, and maybe Josh can share a little bit about post-election litigation. So we've seen an extraordinary volume of election litigation in this country in the lead up to this election, in part because there's been some interesting scholarship on funding for litigation and how a 2014 rule change allowed for contributions to earmarked for litigation were sort of expanded, which has resulted in, it used to be that if you spent money on litigation, you were having to take money away from the campaign for other campaign activities like get out the vote activities. Or advertising, and now we have a system where there's a pot of money to spend on litigation, which means that we're seeing a lot more litigation, arguably, as a result of that rule change. But it's also become what one of our colleagues calls litigation by tweet, meaning that you're filing a case in court not because you think you have a good case, but because you're trying to motivate your base to get enthusiastic or upset about the election. And so we're seeing a lot of kind of headline litigation where the claims themselves aren't strong, but it's providing kind of a political edge to candidates and campaigns and parties. So it's a very fraught environment because, of course, increased litigation has the effect of people feeling like the election system is unstable or not worthy of trust. But looking on the bright side, you could argue that pre-election litigation is when litigation should happen. That is to say, before the votes are being cast, the more litigation to address concerns that happens, the better, in the sense that those concerns can be addressed before the voting outcome is known. So we're seeing a very sort of fraught litigation environment in the lead up to this election, including some Supreme Court decisions in the last few days and weeks. And so I think, as Josh will describe, we may be in for a little bit of a ride after the election, depending on whether or not the election is close.
Yeah. So. I don't know if Chad and Rebecca, you think this. I often say that what's bad for the country is good for us professionally, and things have been way too good. But the amount of litigation is one of those things. So election lawyers in the U.S. refer to the margin of litigation. There's usually a margin of error or a margin of victory for a candidate. We think about the margin of litigation, which is how much do the vote totals need to differ? How much does the margin of victory need to be such that it takes the election outside of the likelihood that you have a lot of litigation? So the question of how much post-election litigation we'll have that could actually be meritorious it really depends on whether the election is actually close between the two presidential candidates and a state that will make a difference to the Electoral College majority. So I mentioned my nightmare scenarios. One is that 269 tie. The other is the Electoral comes down to a state like Pennsylvania, and the margin between the two candidates is 1,000 votes. Yeah. Then you're in the kind of Bush v. Gore, which is the case that decided the 2000 presidential election. You're in that kind of a world. So what sorts of things? So if the margin is much higher, or the state won't matter because one of the candidates has won enough states to have Electoral College majority, then you might see a lot of lawsuits filed, but they won't make their headline lawsuits that create a political narrative. But in many ways we can kind of ignore them because they're not going to make a difference in who takes office on January 20th. But if it does come down to one state like Pennsylvania, you'll start to see litigation about mail-in ballots, those ballots that were set aside and not counted. In Pennsylvania, they had this rule that they have to have a secrecy envelope. So the voter puts their ballot in one envelope and then puts it in a second one. Well, a lot of voters forget that first secrecy envelope, and so they're referred to as so-called naked ballots. Yeah. And there's probably, the last number I saw was maybe 2,000 or so far that have been returned without that secrecy ballot. So if the margin of victory is less than 1,000, whether they count those votes could make a difference. Also, ballots that have been mailed in but are missing a postmark, but they arrive before Election Day. Well, we know they were sent on time, but technically the law suggests that they shouldn't be counted because they don't have a postmark. We've already seen some litigation through the courts in Pennsylvania about these issues. In some ways, the parties are trying to set up to answer the question. In other ways, some of these lawsuits I think I refer to as kind of zombie cases, that they're there for the candidates to then embellish upon if it looks like they'll actually make a difference in the outcome. So we could see some of those cases get resurrected after the election, again, if the count is close enough.
And I think one quick thing to ask you both about is the difference between mandatory recounts and contests of elections. Because I know I don't know how many, did they have 2 counts in Georgia? I forget, but just the difference between the two, because they could both likely happen.
So I'll defer to Josh on this because he has the sort of authoritative law review article on election contests. So he's the man to ask.
Thank you. So there's 2 processes, right? So there's the recount part where in many states, if the margin is below a certain threshold, like 1% or 0.5%, then the state goes through a process where they're actually recounting the votes. But then every state has statutes on the books for how to contest the election. And in fact, the process for contesting it differs based on which office is involved. So states set up a process for the contest of a gubernatorial election, a governor's election versus president. Some of them, the processes are kind of wacky, like they have a subset of the legislature that acts like a court, or a case goes directly to the state Supreme Court. Some of them are just sort of the normal litigation, the normal course of business. So as we watch the next several weeks, it's important to understand the various processes. So the voting ends tomorrow. Then they have what's called the canvass, which where the local boards basically verify all the processes. They certify that to the state. The state election officials will announce a result, and that can then trigger the mandatory recount process. States have deadlines for when that has to be done. And then if the losing candidate thinks there was some problem, and that's when they go ahead and file the election contest, and which is not mandatory, that's discretionary. So there's various stages over the next several weeks to a month and a half. The lead up to that electoral college vote that you mentioned will happen on December 17th.
And I'll just add that I think it's really important to understand that courts understand post-election litigation in every state. In other words, it's very routine to have recounts, to have contests. There are dozens and dozens and dozens of precedents in every state where there's a rules-based process for how to address either election irregularities or close elections where recounts need to be done. And so this is something that judges in the United States are familiar with and know how to do, and it's a process that will unfold in a very orderly way if it comes up.
Yes, and I think it did in 2020.
Yeah. For example.
Yeah, exactly. You're both professors, and you're dealing with a lot of college students. How do you think young people are viewing this election? And are you seeing more interest in election law with your students or not? Because it's the future of all of our work. How do your students see this election?
So William & Mary Law School has become a hub for students who are interested in election law. So we have students coming to law school for the express purpose of getting interested and involved in elections. And as Chad mentioned, we've sent quite a few interns his way, but we've sent them all over to places in Washington, D.C. at federal agencies, state election administration offices, state legislatures, and U.S. Congress to sort of drill down on how our elections work and how we can improve them. And so I think there's a lot of interest, at least at William & Mary, and I think a lot of other places around the country where young people are really sort of looking at this system of elections and wondering how they can get involved and how it can be fixed.
Yeah, 2 things I'll mention briefly. One is that many law schools now have people like me and Rebecca who focus on election law, and that wasn't the case 15 or 20 years ago. And that's growing more and more, where some schools even have more than one scholar that focuses on this area. So I think you're seeing a real growth in interest, and that probably stems from Bush v. Gore in 2000 and the continued litigation and the salience of these issues. The other thing you asked about our students, I found it really fascinating to sort of be told or understand that because this is Donald Trump's third time running for president in the past 8 years, many of our students who are in their young to mid 20s, that's normal. Like they came of age politically as with Donald Trump as the candidate and the kind of campaign that he runs, and the kind of vitriol that you see. And so I remember a student remarking to me when they watched the vice presidential debate between Tim Walz and J.D. Vance, they thought it was weird that it was so civil. Because the presidential debates that they're used to were not. And so I think that's unfortunate that we've gotten to this era where the young people are coming of age politically, where things seem to be so heated. But that has been a reality of the way they see things.
Great. Well, we're out of time. Again, I want to thank all of you for the work that you do. As election geeks, could probably talk about this for hours, so we'll spare you. But Josh, thank you very much. Rebecca, thank you very much. And if we see you throughout the next few days, please let us know if you have any questions. So if you would thank the panel with me, I'd appreciate it.